All right. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. We're here today in the matter of Carter's Inc. versus CR2 Enterprises. Our number CV130734. These proceedings are being audio and video recorded. We would ask each counsel to identify yourself and your client at the beginning of your argument. Each side has 20 minutes. Appellant's counsel is responsible for reserving whatever time you'd like to have for rebuttal. We have read the briefs and we've conferenced this matter this morning. And with that, you may proceed.
May it please the court, I want to apologize for my voice. And I will be brief in my comments initially because, quite frankly, I don't want to irritate you too badly with the sounding of my voice. My name is Gary Doyle, and I represent Carter's Incorporated. I quickly make sure we all understand what parties are involved here and what their position was in all of this. It was my client, Carter's Inc., who was a subcontractor landscaping company. There was Jade or CR2 that was the owner of a project that my client worked on. There's a company called PFG Construction who was the general contractor who arranged for my client to work on the project. And then there's also a bank, Sunrise Bank, who was apparently involved in some of the transactions. Now, I want to cut to the chase on kind of where we see this case coming from. The primary argument, obviously, is whether Jade paid PFG, the general contractor. Our claim is for unjust enrichment. And so Jade's argument in all of this has been, well, Carter's, you don't have any evidence that we did not pay PFG. And we searched for evidence that Jade did pay PFG. And we couldn't find any evidence that they had paid PFG. And in fact, we asked Jade, what evidence do you have that you've paid PFG? And Jade's response to that was, in essence, what were the invoices that PFG submitted to Jade and the bank for payment, and a statement from allegedly the owner of Jade that we paid these invoices.
Did you ask PFG if it got paid?
PFG is no longer in existence. They were part of this lawsuit. They never filed a response. They never had any counsel. And so there was. I did speak to the controller of PFG, the person who was allegedly the controller at the time these transactions were to have been occurring. He had no recollection of any payments, whether they were received or not. He had no idea where any records would be. And that was the problem there, is there was no source of evidence from the PFG side of it either. They disappeared for all intents and purposes.
But PFG never took action to collect?
Absolutely not.
Okay.
Nope. And everybody, all of the subcontractors seem to think PFG took some of the money, and that was kind of what created some of the problems, I think, from Jade's perspective and from everybody's perspective, is we weren't the only subcontractor that didn't get paid. If the court reviewed the underlying case, there was, I think, a dozen subcontractors. In fact, there was, if I recall correctly, 3 separate cases that were filed in this that were all consolidated into one single case to adjudicate the various claims by the subcontractors. So you get to the problem that Carter's had, that we had with Carter's, trying to present evidence that no payment had occurred. Now, one of the issues that Jade raises is, well, you could have gone to the bank and asked them. Well, the bank, as a party to the underlying lawsuit, had disclosed all of its records, which not only would they have disclosed them to us, but they would have disclosed them to Jade as well. And we went through them, and we couldn't, I didn't see any specific records that would have indicated that PFG had been paid by anybody. So so at that point, I'm feeling, well, Jade hasn't given me anything that shows payment's been made. The bank doesn't have anything that I can identify that shows PFG has been paid. PFG doesn't have any documents, period, as best I can figure, as best I've been informed. So I filed our motion for summary judgment saying, listen, there's no evidence to suggest that Jade has paid PFG. And
When you say no evidence, there is an affidavit from someone
That's
saying we paid in full.
and I will get to that, because the interesting part about that affidavit is during our oral argument, Judge Ronan asked counsel, says, how can you not have any evidence that Jade paid PFG? I mean, these companies should have mountains of records showing this stuff. And whereas the affidavit says that Jade paid PFG, counsel's statements that oral argument was, well, that's not really what happened. The bank actually paid the bills, and our line of credit would go up correspondingly with those payments as they were made, which would have been, and that's fine. Well, then show us those account statements that shows those account balances on the line of credit going up correspondingly. I mean, there would have been plenty of sources of information to suggest the payment was made.
I guess one of the concerns I have, though, is under Comerica against Mahmoudi, the movement who has the burden of proof has to submit enough evidence to compel any reasonable juror to find in its favor. And I understand that it's possible to draw an inference that there was no payment, but how do you meet that standard here?
As far for a motion for summary judgment, I will concede that it is a high hurdle, and that's one of our arguments in this case is, well, if our motion for summary judgment isn't to be granted by the trial court, I can understand that to a certain degree, and I'll get to some of the reasons why that may not be the case, but assuming the evidence that they have is admissible and usable at trial, if we can't reach that burden, I don't see how they can reach the burden either for purposes of a motion for summary judgment and the hurdle that
Well,
is.
but the burdens are different for a plaintiff and a defendant.
Correct.
Right. So
I understand
they
that.
can't meet, they may not meet the burden that would compel any reasonable juror, but what they have to do, since they don't have the burden of proof on this issue, it's your burden of proof, is present enough evidence to show that you can't meet yours, right? So that, I mean,
Right.
it's a different standard.
I understand what the court's indicating, and I think our
I don't mean to indicate anything.
Okay.
I'm interested if you think there's some aspect of the various standards of review that I might be missing.
No, I think the court is right generally. I think, and this is kind of is obviously kind of a unique situation. The underlying facts that I think most owners of a project like this, for a lot of purposes, would have kept meticulous records. I mean, you've got, not to mention the fact, tax liabilities that they're going to have to keep the records for 7 years based on that. So they should still have these records in possession.
Sorry to interrupt. What if this were a situation where it were simply the owner saying, I just paid cash, and they provide an affidavit saying, we paid cash. If the contractor is no longer around, you can't find the contractor. Does the owner meet their burden? If you're suggesting there's some sort of burden on the owner by saying, I paid him in cash, and why isn't that enough?
Well, I think the question then would be, what's the source of the cash? I mean, did you take it out of the bank and pay him in cash?
Why would that matter?
Well, I think to have paid some of the invoices that were due at the time, which were over $100,000, well, actually over almost $250,000, the particular amount that was due at this time, to have paid off that would have taken a substantial amount of cash. Now, I suppose he could have paid him in small increments, but I think it's relevant, what the source of that cash would be.
Well, the theory here is that the bank paid. I mean, does it really matter who paid? If there was a payment made and the general never objected or raised a claim that it was underpaid, isn't that enough for purposes of the dispute you have with the general?
The fact that the general never raised an issue about being paid or not?
Well,
I guess
that's sort of make weight. I mean, the general never raises an issue about being paid, but there's some evidence that the general was paid by someone on behalf of the owner. Isn't that?
Well, I'm not sure that evidence exists. That's the problem. Is I was never able to come across any evidence that the bank did pay PFG.
That was the question, actually. I had, you indicated at the beginning of your presentation that the bank had produced its records as a matter of course in the litigation. And then it sounded like at the hearing, opposing counsel gave further information that while the money didn't come from the owner, it came on behalf of the owner through the bank. And so my question is, with that additional information, did you then go back to the bank and say, look, is there a line of credit document that or account that is not included in this other production of records?
After the motion for summary judgment was ruled upon?
Well, I don't. You had a hearing. Was it ruled on at the hearing?
No, it wasn't. I mean, there was no. I didn't. Did I make a further request to the bank? The bank was out of the case by then.
Or
I guess
at least an oral 56F motion to the trial court saying, you know, here's some new information. I need to track this down if the court's not inclined to grant my motion.
that did not occur to me. Yeah, I guess I could have requested the line of credit documents from Sunrise Bank. If I remember correctly, they did have some of those documents in their file. Unfortunately, the file was not the best organized, and as you may know, Sunrise eventually was taken over by another bank. So I did not do what the court has suggested, though. Which so anyway, and then one of the issues that we raised in our original motion for a response to Jade's motion for summary judgment, and kind of throughout the proceedings, was the fact that they never provided us a disclosure statement, even though I asked for it a number of times. I made oral requests to counsel. I sent them written requests. Can you please just provide me a disclosure statement that gives me something to go with here? And it was never forthcoming. It was odd that when we did finally receive an application for attorney's fees, which I'll discuss a little bit next, they actually apparently prepared a disclosure statement, but they never provided it. And for the life of me, I can't figure out why. I mean, it wouldn't have been a very complicated disclosure statement by any means. It would have just been basically, we paid, and here's our evidence that we've paid.
But you were given notice of the defense and who they intended to call as witnesses.
Well, they showed the owner, that Yakov Ross, as a witness, but I didn't really know why he was going to testify. And at the time that trial was pending, there were other issues in the case were what everybody assumed was going forward on trial. I don't think the unjust enrichment claim was really going to be that much of an issue at the time. And so I really didn't know what Mr. Yakov would be testifying about. And the court's referring to a pretrial statement that the parties had submitted, a joint pretrial statement, correct? And that was the only mention of Mr. Yakov's name in all of the pleadings, other than obviously the motions for summary judgment.
Wasn't it clear that their defense was, we've paid?
The discussions I had with counsel were that he thinks, I'm hoping my client has some evidence and that they were paid, because nobody was really sure if the general contractor was paid for paid for this work. And that was part of the problem. Even in the bank's disclosure statement, they indicated, and this was the one thing that concerned me about the bank, is their statement was, well, allegedly PFG has been paid. They weren't clear about it. They said, we're under the assumption that PFG has been paid. And so, given that, I was thinking, well, then how did they get paid? Somebody's got to have some information here that shows that PFG was paid. And that's why I was so confused about, how could it be that nobody really knows if PFG was paid?
But if it's your burden, wouldn't it be incumbent on you to find somebody from PFG to say, no, we were not paid?
And I tried. And I requested information, requested documents, and there was just nothing there. There was nobody. In fact, contacted the attorneys that were involved with a bankruptcy case, and they said, there's nothing. We've got nothing for you. So it was a very odd situation. I found it very hard to believe that at the point I wasn't one way or the other. If there's proof out there that shows they've paid, that's fine. Just give it to me.
There's certainly, was there proof that the general was in fact billed for the work? I mean,
Yes.
The general actually submitted payment applications that included this work.
Yes.
So is there any inference to be drawn from that?
That the payment applications were submitted in that.
From the general to the owner.
Correct. That, well, and the inference would be that they weren't getting paid because it had been quite a while since they had been paid.
I guess my point is if you cobble that together with the affidavit statement, assuming it's admissible, is that sufficient to prove?
Well, and that's what they're contending, is with his statement, and that's what the affidavit says, is we received these invoices and we paid them, or these requests for payment. And that's their evidence that payment was made. And I don't know, I guess I'm here, kind of from the perspective of a subcontractor who's stuck in this situation. He's in a tight spot. He's got a general contractor that's completely flown the coop, and a owner that's saying, well, we've paid. It's like, well, could you have anything that suggests you paid? Because the general contractor doesn't have any documents that I can access, and there's nothing out there for me to show one way or the other whether you've paid or not. And so when an owner says, well, no, we really don't have any checks, canceled checks or bank statements or anything that clearly indicates that payment was made, then all it takes is the owner's statement to say, well, yeah, we paid. And that's, some of the, and I understand that with the burdens, but, some of the recent cases, well, one recent case in Wells Fargo v. Allen where the bank submitted an affidavit, and this court has said, well, that's not necessarily enough unless that affidavit is really specific as to how these payments were made.
But Wells Fargo was the plaintiff there.
I understand. And that's why I pointed out the burdens are a little bit different. But nevertheless, it comes down to what the evidence is. And if the evidence in his affidavit had been, okay, we paid these, and here's how we paid them. We don't actually have, the really source documents, but I do know this is how we paid them, and this is when we paid these bills. And none of that information is even provided. There's really no specific information as to when these bills were paid. And that's the concern that we have as to whether, in fact, PFG was paid. And keep in mind, I'm not here because, we'd like to know one way or the other. And so the last point, and I've raised the issue with the disclosure statement. The last point is, and I just want to make sure I get this in, is with the attorney's fees. They've requested attorney's fees at this point. The court's probably seen my response to that. They have never requested attorney's fees except for after the motion for summary judgment when they requested attorney's fees and made the statement actually that the court had ordered that costs and attorney's fees be paid when in fact the court hadn't ordered that. And none of their prior pleadings had any request for attorney's fees. And I think it's, that this court is precluded from granting attorney's fees to Jade at this point as well, because the request has never been made. They've never provided any statutory basis for it in any pleadings. And that pretty much brings me to a conclusion. Thanks.
Good morning, and may it please the court. My name is Thomas Mooring, and I represent CR2, the owner of the property in question. I wanted to give just a little bit of additional background to what Mr. Doyle has described, which really was a very complicated case. Various cases were brought between different subcontractors, some represented by a handful of subcontractors were represented by the same attorneys. Everything kind of got consolidated in. What ended up happening is that Sunrise Bank came very late to the game because through the course of discovery, we uncovered the fact that this was a blown title case, that the mechanics liens had been recorded prior to the reachback statute that the liens provide. So the bank came in to defend their title and eventually paid off the mechanics lien claimants. And that's important because the earliest of the cases was set for trial. We filed the joint pretrial statement. We were getting ready to go to trial. Then there was some motion practice that included amending complaints, things like that. The bank got involved and said, okay, let's see what these claims are, and resolve those mechanics liens to protect, or the title company, to protect the bank's interest in that real property. So that's why, if you look at the timing of this, it's sort of unusual that we had a pretrial conference and then 18 months later we're arguing a summary judgment motion. That's how it came about. And there really are two summary judgment motions. I think it's important to focus on that. Carter's brings a motion that says, as a matter of law, we're entitled to payment. Bang. That motion is denied by the trial court. That's not really something that we're here to address. My briefing talks about the idea that denials of summary judgment are only reviewed on an extraordinary basis. Then Jade brings a motion. That is a standard motion that a defendant would bring. Jade says, we don't think you can prove your case. And if you can't prove your case, we don't have to go to trial. There are 5 elements that you have to prove to demonstrate unjust enrichment. Arizona courts make clear that there's 2 types of unjust enrichment. One where the owner benefits and pays no one, and then the case we have here where the owner benefits but pays somebody who doesn't pay the plaintiff. That motion was granted by the trial court. I think Judge Swan's hit it exactly on the head, that what we said to the trial court at that level, Jade 2 said, we don't think you can demonstrate your claim. Carter's then has the burden to come forth, create some disputed issue of fact, fails to do so. Judge Ronan properly enters summary judgment. Carter's failed in its attempts to prove any of those 5 elements, and as such, didn't show that any benefit conferred was unjust. And we heard from Carter's counsel this morning about the things that Jade did or didn't do, and that may have complicated the record a little bit. The reality is Jade didn't have to do anything. We could have filed a motion for summary judgment, said you can't prove your case, sat back, and then waited to see what evidence was produced, or if a 56F motion was brought forth, and then the judge would have a chance to rule on that.
Well, I think you do have to at least say we paid.
I think that's right, and I think we did.
But why not, in saying that, why not provide some records showing how you were paid?
The records that were available to Jade are the same records that were available to everyone else, and counsel's already explained to you in looking through it, this really was a horrible mess. And it was a horrible mess at a very difficult time, and banks are getting taken over, the contractor's going bankrupt, nobody can find documents, nobody can find paper. All that we have is, the cleanest thing that we have is Yakov Ross, who is one of the members and basically the financial guy at Jade 2. And he says, every month I get a bill, I get a statement from PFG, a progress payment, a payment application. Every month I get a note from the bank that says, here's how much you owe. And they match. I got to pay the bank more money every month because I'm incurring charges.
You provided the statements, the bills, but then you didn't provide anything from the bank that shows this match.
Because at the time that we were doing this, again, well after the construction was completed and well after all of this other stuff had happened, what we had was a statement of how much the line of credit was. So, traditional construction financing. Jade obtains this dirt, goes out to the bank and says, we got these bids from PFG, we need you to pay for this. And the bank says, okay, we'll pay for that. Along the way, they get a certain line of credit to build this building, and that line of credit is tapped. So at the time that we're looking backwards at all of this, we know what the current balance is, and we know from the contemporaneous records of the payment applications that each time a payment app comes in, it says balance forward 0, new payment this, and then we get another application from from PFG that says balance forward 0, new payment this, and that goes on. And we do know that Carter's work was included in those draws from PFG, and we know that PFG consistently showed 0 balances as they went forward.
But were there no internal accounting documents in your client's business to reflect the ledger entries showing that credit balance?
We knew how much we paid to the bank on a monthly basis, which constituted, because again we're talking about a lengthy period of time, constituted at one point interest-only payments based on the amount of the line of credit, and at one point
I guess my
amortized.
question is, wasn't there some documentary evidence of that, as opposed to simply somebody making a conclusory affidavit saying, oh, we paid it?
All that the evidence shows is what we were paying to the bank.
In other words, it's not there's no designation of what the payments were going to satisfy?
Correct. One of the payment applications that stands out in my mind was for roughly $167,000. That comes in, and then it shows paid, and the next one comes in fresh. But there's not a corresponding check that's for $1,672, which represents 10% interest on that amount or anything like that. It's a rolling cycle, so that as the line of credit increases, and keep in mind that the payment applications aren't timed along with the bank cycle. I mean, the payment applications could be 45 or 60 days. The bank's inspector is going out and looking at the property, making sure that city inspections are completed before the payment apps are processed.
But
So
if,
it's not
if they're not synced up with what the bank's paying, I may be misunderstanding what you were saying. I thought you were saying that the invoices showed a zero balance. Why would there be a zero balance if the payment hasn't been made yet? I'm having a hard time gleaning anything from the invoices other than this is a bill.
Right.
Are you saying that we can look at that bill and understand that a payment has previously been made on other bills, or is it just this is a bill for some work that needs to be paid?
We can look at that bill and ascertain that previous payments have been made, because we had a series of bills, and each one began with a zero balance, which is indicative of the fact that the prior bill had been paid off. They're not discrete bills, they are rolling bills. But here's where the timing comes an issue, and I'll try to use an example from this year. The bank's first payment, PFG would submit a payment application on January 1, and the bank would go out and do the inspection and make the payment within 10 days. But our billing cycle starts on January 5th. So if this was the very first draw, we'd have a zero balance in January. That would not be indicative of no payment. The payment would have been made by the bank in the middle of January. Then in the February cycle, we'd have a bill for the amount that was paid January 10th. Then PFG's next payment application would come out showing the zero balance from the prior bill, and so on and so on. So that when I say they don't sync up, what I mean is the bank is charging monthly interest to my client. But the monthly interest charge may be the same for 2 consecutive months because no draw has been made on that line of credit. So the best evidence of the payment is those invoices which were submitted and the affidavit of Mr. Ross. And that demonstrates payment. Again, when we look at the burden to be applied, it is the move-on's burden. But what we said in our defensive motion is, show me what you got. And the court considered that. The argument essentially is, well, I had trouble coming up with some proof that your enrichment was unjust. I cannot demonstrate the fourth prong of the elements. So you should deny summary judgment. And that's just improper burden shifting. The fact is, in the absence of that information that the plaintiff can't bring forward, the verdict is properly for the defense. In short, again, the cross motions make this a little more murky than it could have been. So I think that the best way to analyze this case is looking at Jade's motion. And Jade did what defendants do all the time. They said, plaintiff, we challenge you. We don't believe you can prove it. Here are the facts on which the court must base its decision. Carter's comes in and says, well, we don't have a factual dispute, but we don't think that you've met your burden. That's a fair argument, and it's one that Judge properly considered, and he properly ruled against them. So we believe the trial court should be affirmed. I want to briefly address the issue of attorney's fees. Mr. Doyle talked about the fees below. I think that there are two separate claims for attorney's fees, and we've brought before this court a claim for fees on appeal, which are separate and distinct from the claims below. I don't believe, and my research doesn't indicate, that the fact that they would somehow be tied together. This court has jurisdiction under the statutes and its rules to award attorney's fees to the successful party before the Court of Appeals, independent of what the trial court did below. To the extent you're inclined to consider those arguments, you may, but I think you should consider them in light of the situation that you see very regularly where a trial court in a 12-341 action says, I don't really know who prevailed. We're just going to say everybody bears their own fees and costs. You can still award fees on appeal independent of the trial court's decision. Barring any questions, I'll sit down. Thank you, gentlemen.
Thank you.
I'll be brief. I think Mr. Counsel misspoke when he said we couldn't prove any of the 5 elements of unjust enrichment. I think he meant we could prove all, because we did. We proved most of them. They're all pretty clear. My client was detrimentally affected by this, and 4 of them. It's just the one element that is at issue is whether Jade was enriched by the action or unjustly enriched, and so I just want to be clear for that. Mr. Mooring brings up some really interesting information for the court today about how the process worked and what was happening. And if Mr. Ross had been that specific in his affidavit, there might have been a different result. But that's not what his affidavit said. He didn't say what the process was, because if he'd had this real specific process of, we would get the request for payment would go to us and to the bank, and then we would get a corresponding statement from the bank showing an increase, and it was always consistent with what the request of payment was. It would be consistent, but none of that information was provided in the affidavit.
Well, I would agree with you if there's just some evidence from the contractor saying, no, we weren't paid, or we were paid some but not all. But absent some evidence that suggests, that contradicts just the statement that we paid everything, it seems like you've got a big hurdle.
And I'll fall back to the position of, we think that the lack of evidence of payment is actually kind of our evidence that the payment wasn't made. I mean, it's tough to prove that payments weren't made unless, in this case, if PFG was a valid party to this case and they had said we weren't paid, that would have clearly been the best evidence possible. We didn't have the option of PFG coming in with that. And so you had to fall back on what you did have, and so we went to the 2 sources who could have provided proof of payment, and that was the bank and to Jade, and neither of them were conclusive as to whether these requests for payment that under which Carter's bills were sent were paid. Now, in response to the attorney's fees, I think the court, if they see Ayers v. Red Cloud Mills, it's pretty clear that the Court of Appeals has taken the position that, listen, if you haven't requested attorney's fees during the case in chief, the underlying case, we aren't permitted to grant attorney's fees at this level.
Thank you both for your argument. We will take this matter under advisement.